Good evening. It's 7:01. Time for the East Lyme Planning Commission meeting. I'm just going to start with a roll call. We have one alternate sitting with us tonight. Start from the right.
Thank you.
The roll call.
I'm sorry. Cindy Collins.
Brian Bombeck. Tim Leducer.
Rich Gordon.
Tom Finney. Nick Menapace.
Thank you. Now time for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yeah, that's okay.
I've got my zoning.
Next up is call for additions to the agenda. We had one memo. I think Ms. Heller wanted to be added to the agenda.
I believe it's in your packet. I think it's pursuant to the zoning amendment
Oh, okay.
application.
We'll go and add that to the.
Correct me if I'm wrong, it's related to the zone change, correct?
Yeah,
Part of that. Yeah, so that's part of the record.
Oh, okay. Okay. So that's even okay. We can add that. Next up is public delegations. Public delegations is the time when members of the public are invited to speak to the commission about certain matters, issues, or concerns related to approved subdivisions and in-house proposals, or general topics of discussion are open to comment. Agenda items, referrals, applications subject to a decision by the commission, a public hearing, or litigation may not be discussed. The members of the commission will not directly answer questions or make comments during delegations. Anybody in the audience? We do have a continuation of a public hearing later in the meeting. Okay, thank you. Next up are reports, communications. I don't think we have any. Zoning representative, I think.
Yes, I have something for that one. So I went to the March 20th zoning meeting. Deep was read later for Deep, but also agreed with us the text amendment being against the POCD. Because I always forget what Deep actually stands for. But then also the zoning committee did agree with planning that it was against the POCD for the text amendment for float and voted against the floating zoning. Vote was 5-1. I don't know if that's relevant, but that's pretty much all that happened for the meeting. Was they had the report from Deep, and then it was debated, and then voted on for the zoning committee.
Okay. Thank you. Next up, ex officio Don McKenzie from the Board of Selectmen. Do you have any updates?
Good evening. Only thing I have to report is that long meeting last Wednesday regarding short-term rentals. Final presentation was made for us. We're not in deliberation yet, but presentations were made in front of us.
Okay.
For discussion.
Okay.
Part of the topic.
Right. Thank you. Planning Director Gary Gaishel, do you have any updates?
Don't have anything that's on the agenda.
Okay. Thank you. Subcommittee reports. I don't think we have anything. Chairperson, I don't really have any updates right now. Next up on the agenda is the approval of the minutes, the meeting minutes of March 11th, 2025. Any discussion? Okay. If not, need a motion to approve, deny.
So moved.
Oh, thank you. Any second?
I'll second. Oh, sorry.
Any other discussion? All in favor?
Aye.
All opposed? Any abstentions? Nope. Okay, passed unanimously. Approval of the minutes. Next up, we have a continuation of the public hearing for the application of Kristen Clark from Duval Partners, LLC owner, for an application of a 20-lot subdivision of approximately 12.67 acres of land zoned RU 80 on property located on the south side of Holmes Road, between 20 and 38 Holmes Road. Mr. Garrity,
Thank you. Okay. Thank you, Mr. Chairman, members of the Commission. My name is Paul Garrity. I represent Duval Partners and Kristen Clark with regard to this application. On April 2nd, at a meeting I had with Mr. Gaishel, I submitted a letter which I'll hand out to the Commission requesting a continuance of this to your March meeting. Presently, we have been addressing issues with Ledge Light Health District. We had submitted, or had done the test pit digging back in November. It wasn't until February that Ledge Light actually got out, after we made the application in November, to inspect the holes. There were some issues with a few. We still have some issues with respect to back and forth with Ledge Light, so that we don't know whether they've approved every single lot out there. So we're going to ask for a continuance to the May meeting as a result of that, because we really can't move forward with any additional design, including the fact that depending upon the outcome of those discussions, the road might have to shift a little bit, whatever. So we can't really design the construction phase of the road until we know where the road is actually going to be, if at all. So
Okay.
I can just,
You do have copies of that letter in your packet? You have copies?
I know you have 90 days altogether that we can continue between the public hearing and any discussion afterwards from the board.
The applicant has a solid 65 days
Would you
to
like-
pull from, this is 30 days of meeting, so we have ample time. As it stands now, so we have to make a decision until within June, this will.
Okay.
yeah. And it also attached to the letter was our memorandum that my client, our professional engineer, Ms. Clark, prepared and submitted, that addressing some of the concerns and some of the issues she had with the response of Ledge Light to the initial application.
Okay. I was going to ask about that. I can entertain a motion. For the public to speak, they still can speak at this. We still in the middle of a public hearing, so I assume they can speak if they wish. Or
I think that the applicant is asking is just.
for continuation, just postpone it, then they shouldn't speak at this
Right.
point.
We shouldn't have discussion necessarily tonight, but the next meeting.
Next meeting we can do it. Okay.
Public discussion.
Okay.
And you'll have an opportunity to
Mm-hmm.
be heard.
Okay. Double check on
Can
that.
I ask a thing for that one though? Is that I know that were we possibly not clear enough with people that was not going to be on, because we did have an opportunity for public delegation,
Right.
but people did not know that the public hearing was not going to be happening.
Right.
So I'm a little unclear with that. I understand that there's nothing really new for this one for it, but
If you want to hear from the public tonight, you can.
yeah,
Yeah.
I would
Well,
still.
I object to that only because we're going to have people commenting on things tonight which may or may not change in there, and there's going to be, by the time the May hearing comes around, there'll be additional information in the record, and also that staff is going to have to review prior to that meeting. So, comments tonight, I'm not sure if they're going to be pertinent to the application itself.
Would it be possible then for us to open this up as public delegation again, so that people may not be, they can talk about this one,
Yeah.
technically anyone is
Yeah.
able to comment on this.
But the problem with the public delegation issue is it's on the agenda for tonight. It's a
But
public
just for
hearing.
that, I am asking.
No, understood.
Okay.
Generally protocols that they ask for continuation, that we limit.
Typically, I have no issue continuing the public hearing. There is no reason why we should not.
Okay.
Right.
I would say, in terms of whether or not you receive public testimony
Right.
tonight, applicants requesting that we don't, because really what's new to share? There's no new information
Right.
submitted since the last meeting.
Right.
Yeah.
Are there
That said,
different people here to
there are
talk?
people here who may have something
Right.
to say
Right,
and may not be able to make it to the next meeting.
right.
Right.
If they have some new information that they'd like to provide, I would encourage that they maybe stick to new information. But aside from that, I'm not sure what they're gonna talk about, other than maybe their just personal preference.
There are
I mean, that's,
They're entitled to, so.
What does the other commission members feel about?
I feel they should be able to talk.
I feel they should be able to talk as well.
Yeah,
Okay.
I do too.
There are people here tonight that weren't able to make the last meeting,
Right.
so they want to be heard.
Right.
okay.
Okay.
So we're gonna,
We can still vote on the continuation and then hear
Yeah.
Well, you can't vote on the continuation
until
until after the public speaks.
public speaks, right, okay.
Right, and I'll just note my objection to that for the record, but.
No, okay, no problem. Okay, all right. Does anybody wish to speak from the public, or? Just state your name and address.
Hi, Terry Casey, 55 Holmes Road. Just a little concerned, the nature preserve surrounding this proposed cluster housing has hunting.
sorry.
It also, in the back, has the Eversource transmission lines. And these are, they carry power. They're not like something on a street. And Eversource has put up signs, warning, danger, no trespassing. That's on the road, I observed on Upper Walnut. There's nothing safeguarding the transmission lines behind this project. There's also the likelihood of a large number of pets, dogs. I wouldn't want the dogs to be chasing animals. A lot of dogs like to chase deer on occasion. So I would recommend having a 6-foot-high chain link fence around this development to keep kids out of the hunting area, to keep kids out of the transmission lines, and also to keep the pets from chasing the wildlife. So, thank you.
Thank you. Anybody else wish to speak?
Hi, my name is Paul Mastroianni, 23 Holmes Road. I should get set up here first, please.
Sure.
I'd like to just go back a few years, short and sweet. The same company that sold us the wildlife preserve out there asked us back about 4 years ago to change the zoning to RU80. This way they can sell us the property, and they kept approximately 12-acre properties left. First property they sold to Calkins, which is those houses up there now. And the second property is what we're talking about today, which they want to change the zoning again to suit the Duval people to make money. Now, I do have some stuff on here. One thing I'm not sure about is if Duval, I don't know if I can look at him or not, but if Duval, like to give that, did some surveying. Can I hand this to you? Did some surveying out there. Because if they did, they're like right behind my property. And the maps I gave you were the survey sticks, the 1,000-foot parameter around, which is about where those survey sticks are. So if they sent somebody out there, they're trespassing on somebody's property, and they could be fined for each individual, because there's nothing in his, that he gave to the council that he had permission to cross someone else's property. And if you look at what I gave you, you'll see exactly what I'm talking about. So I don't know if it was their zoning or not, but if it was, they crossed people's lines, and they're not supposed to. The other stuff I like to talk about is some of the stuff that he put in last time. I'll start from the beginning here. They call it an irrigation pond. It's not an irrigation pond. It's a dead pond. Because as soon as you put this pond in there, if it doesn't have free-flowing water, it's a stagnant pond. It's going to look like the pond at the end of 161 and 85. It's all moss. They're also going to put a dry system in. So that means, which he hasn't put in yet, you need a diesel backup to pump the water from point A to point B. The second thing is you gotta get it started. So who knows how it starts? Does the fireman start it? No clue. I didn't see anything in here with the fire marshal responding to anything that they spoke about. I highlighted some stuff. I'm sure you'll go through it. Another thing he puts in here says each lot owner shall have one vote in determining the nature and extent of required maintenance, blah, blah, blah. The lot owners are devolved, so they have 100%. So to me, that's not right. The other thing, which I think is a joke, you're putting solar panels on these miniature houses up there. Then you're going to face them, so they do a south, so he puts in here that you might have to cut some trees down. What trees, I don't know. Hopefully it's on their own property. Why? I don't know, because I don't have solar on my house, and I don't spend a lot on electricity. The other thing is, I'm still talking about this pit. And I gave it to you. He has two different ones in here. One along Holmes Road and one along the back edge of where he's going to be building. In there you'll see that he has dimensions. 300, which is on his Schedule A, by approximately 800. If you calculate that out, it comes out to be about 240,000 square feet, but there's no depth on it. Doesn't even say what it's made out of. To me, this should all be up front and put with the fire marshal. The other thing is, in here, I can't find it right now. It says it's 2 acres. If you multiply that out and divide it by 40,000, you're looking at 6 acres. Plus, he has to get an easement from Eversource to build this on their property, from what I read in here. Let's see. If it runs dry, they're going to use, according to this, they're going to use the, let me find it here. Hold on one second, please. Give me 1 second.
No worries.
I can't find it.
Take your time.
Oh, there it is on the first page. It gives you the size. He says 2 acres. And if you calculate that out, I think it's 6 acres. So that's a false statement right there. It's about the 5th line down on the first page. I have it highlighted. Let me get to this. So this is pretty much what he talked about on March 11th. Well, the day before March 11th, sir, he was in Superior Court, March 10th, talking about the same property for the previous 44 houses that he had, which he didn't mention in the last meeting, because I watched the meeting for this segment, and nothing was brought up about that. So I'd like to go over a few things on that. If you look at the first page, and you go in to the 3rd page, I highlighted the date, March 10th, with the transcript. I pretty much read through the transcript, not 100%, but pretty much a lot of it, so I just wanted to print it out to say where I got all my information from. That's all attached. In there, and like he said at the last meeting, there was no reason, because people are going to come in here and talk about widening the road. And he said, my words, not his. It doesn't need to be widening. Well, if you look at my very first page on 20, line item 5, what do you mean widening of the road? Attorney Garrity, the main, the existing town road as it goes, this project is right on the town border of Montville and East Lyme. It goes through Montville to get to Route 85 there. The road next right down to the town line. In the previous tax, application for this site, which got approved, town golf course, which was how many years ago? Just like those pictures that are 100 years old that he put in. They're suitable with a 22-foot meaning. Court, so you would need an approval from the town of Montville. Garrity, correct. Court, to widen the road. Garrity, right. To stretch about 20 feet. So he contradicts himself from the last meeting to Hartford Superior Court right here. In words, his word. If you go to the next page, 21, the court, but we don't assume in courts. You need approval of the government of the town of Montville. Garrity, correct. So if you keep going down, I highlighted things. I don't want to go through all of it because I know you'll go through it all.
So this for, I didn't set any time limit. Do you know how much longer?
Well, okay, yeah, you guys going to review this?
Yeah, we can read it.
Okay, I just want to get to one thing.
Sure.
I know he's talking with Ledge Light. I'm not even getting into that. There was one thing in here. Let's see. Here it is. Line 23 on 26. Attorney Garrity, no, I think it's the Public Works Department or Water and Sewer, so it might be the Water Control Authority. I'm not exactly sure how the WPC set up there, but that would be just paying the connection fee costs. Now this is the water. Now everybody knows there's no water up there. The pipe is literally at the end of the street from where we are bringing it into the site. Court, this is just water, not sewer? Garrity, correct. It's a lie. To me, that's perjury to a Supreme Court justice. Right there. And I attached on the back the last page. What is your oath of attorneys in Connecticut? You solemnly swear or solemnly and sincerely affirm, as the case may be, that you will do nothing dishonest and will not knowingly allow anything dishonest to be done in court, and that you will inform the court of any dishonesty of which you have knowledge, that you will not knowingly maintain or assist in. What happens if a lawyer lies under oath? It's all attached. I'm saying this out loud for everybody in the room. Planned perjury. A lawyer who would so cooperate would be at risk of prosecution for sobering perjury and disciplinary proceedings, including suspension or disbarment. ID. As such, a criminal defendant does not have a right to testify falsely on behalf of the assistance of a counsel in doing so. So right there, what I gave you, he lied to the Superior Court that he went to court for originally for the first 44. So this was March 11th. That's all I have. Thank you.
Thank you. Anybody else wish to speak?
Hi, Lou Rascott, 38 Holmes Road. My only question is, again, going back to the overdevelopment, the aquifer, everything up there in that end of town, it's not made for development of this size, of this magnitude. But my other question is, the talk is about this fire pond, and this is going to save all, it's going to be the end all the fire protection you need. I can tell you from experience, that's wrong. It's not even close. But to that, is that fire pond going to be available for the rest of the residents up there? Are these going to be town roads, or is this going to be private roads that are part of the subdevelopment? Because if you're going to put a fire pond up there, as Paul just mentioned, nobody else has fire protection, nobody else has water. So it would only be right that this pond is going to be able to be used for the rest of town up that end. There's not even a fill site for a tanker up there. So this pond is going to have to be pretty sizable. I don't know if you're familiar with Horse Pond just up the road in Salem, But that's the size pond that they use in Salem for water supply. So I don't know what they plan to have for this pond, but that's a small water site. That's considered a small water site at Horse Pond on Route 85. That's all I have. I just want to, if they're going to put a water supply up there, be a water supply that's usable for everybody in the area, not just for the development. Thank you.
Thank you. Anybody else? Mr. Garrity, do you want to speak?
Just briefly, Mr. Chair, thank you. With regard to Mr. Casey's comments, the easement that the Department of Energy and Environmental Protection has over the property permits hunting at the consent of the East Lyme Land Trust. And there's only one area that hunting, I've spoken with Mr. Carlson. Mr. Torrance is here, who has done a lot of work with the Land Trust, and so if there's any other questions, I don't want to get too far afield because we're asking it to be continued, but there's a limited area, and it is south of the power lines that hunting would be allowed on, but they have to get the permission of the Land Trust, and so far as I know, at this point in time, the Land Trust hasn't issued any permissions to hunt on the property. Under the terms of the deed thing, all those easements typically allow for the property owner to allow hunting, but it's up to the Land Trust if that's going to actually happen. With regard to safeguards, there's no safeguards out there right now. And when we were doing the survey, and I'll get to that issue in a minute, I talked with Mr. Rascott, I talked with one of the other persons up there who live there, and they used this area as if it was their own. And I said, you can't, because you don't own it, right? So if we're going to talk about respecting people's property rights, we need to start there. This isn't, it's no longer my client's property that they're talking about, but it's the Land Trust property, all right? And you need permission of the Land Trust unless they post it open to the public to go on that property. And the idea of putting up a fence around our property just really, makes no sense. My client shouldn't have to prevent other people from going on to the open space, and the open space is not fenced anywhere else. So the idea of putting a fence around our client's property to protect the open space doesn't make any sense, frankly. With regard to Mr. Mastriani's, and I hope I'm pronouncing that correct, the survey issue and whether the survey is trespass, surveyors have a statutory right that protects them from trespassing in order to conduct surveys. And yes, this entire property was surveyed. Mr. Marine is here, and I think he can testify to that they are allowed to cross boundary lines in order to complete the survey. I don't know, in terms of the comments with regard to the irrigation pond, I don't know where in our design report he was referring to that, but we'll address any comments on that at the next hearing. With regard to providing maintenance or a water system or a fire system pond for all the other houses up there, that's not part of the regulations. We have to do it as part of this particular development, and that's required. I suspect many years ago that there wasn't any fire suppression systems or fire ponds or fire tanks required, and that's why there are none up there now. That being said, I don't see any issue with the fire department accessing a fire tank in the event that there's an actual fire emergency up there. We're not going to restrict the use to that or tell the fire department they can only use it on the houses in the subdivision. So I just want that to be clear. I think that was actually Mr. Rassacourt who had that. The idea that the houses are going to have solar panels, that's not correct. The houses, and your regulations require it, are designed such that they face in a direction that if somebody wants to put solar, they can get the maximum benefit of the solar from the positioning of the house on the lot. All these houses were designed in compliance with the regulation to do that. And that's the comment in the design report about the solar panels in there. Say that the houses have been located in a manner on the lot to effectuate your regulations, which require us to design for the benefit of solar power if somebody wants to use it. And I'll leave it at that for tonight. Oh, actually forgot the most important part. The gentleman who accused me of making false statements to the court. First of all, I think he's wrong. The date we were actually in court on the record was February 5th, and there were two issues or two applications before the court. One was the Boston Post Road application. That's the one he's referring to when he said that there is a water line there. There is no water line to the Holmes Road property. All those comments related to the Boston Post Road application that was before the before the zoning commission when we were in court on this matter and the Boston Post Road matter, which is not, there's no application pending before this commission with regard to that. So to say that I misrepresented something to the court, frankly, I take a bit of offense to that. I understand that he may not have understood that there were two different cases on the same day being heard at the same time by the same judge, but we made absolutely no misrepresentations to the court on that day, and I'll stand by that.
I have a quick question. Sure. Is this still pending, whether Montville agrees or not? Is that?
The issue with Montville, no, I mean, Montville had, when the original application for the golf course and all, had indicated to us if the road needs to be widened, and that's what I was saying to the court, if the road needs to be widened, Montville had already given a written approval to widen the road to 22 feet.
The town had agreed to.
Yes, so we know if that becomes an issue, we can satisfy it. We can go back to Montville and say, listen, we need to widen the road. They've already said you could do it once for far more traffic. I mean, the original proposal that the zoning commission approved for the golf course had somewhere in the neighborhood of 70 to 80 housing units plus the golf course on there. And I think there were upwards of 170 parking spaces that were devoted to the housing and to the golf course. And Montville was fine with widening the road there.
So it's the East Lyme side that's not adequate?
No, the East Lyme side is adequate. It's a section in Montville, probably about 40 feet long, that is roughly 18 feet. There's no curbs or whatever, so the road kind of goes like that, like a lot of the roads do. But Montville said, and put it in writing, saying that they would grant permission to widen the road if need be.
Okay.
I would just note that the private road standards for a low volume road under our regulations is 18-foot wide curb paved width. So the question there is whether, and it's a Montville issue, so I'm just letting you know that. The current, as reported by Mr. Garrity, the current condition of that road in Montville is 18-foot wide, basically curb to curb. That would be compliant with our regulations. It's a separate municipality and district. They have their own governance. So if they require the wide road to be widened, they will let the applicant know.
Okay.
Gary, is it logistically possible to do a traffic study? I know you can't do it after the public hearing is completed, but
I mean, you could certainly ask for one. I'm going
I
to suggest you take a look at the number of lots in the regulations and realize that we set the threshold of a low volume road at 20 lots.
Oh.
And
In total?
over 20 lots, you need a second means of ingress and egress. They've got 20 lots with two means of ingress and egress. So I think in terms of the traffic being an issue, it's a non-issue in terms of it's not going to generate a substantial amount. It's still going to meet the standards of a low volume road for the ITE manual. I'm happy to talk to the town engineer about that, want more information on it.
yeah, I think
Yeah,
that would be a good idea.
I also believe that the applicants is a traffic professional.
Ms. Clark is a professional traffic engineer,
I
correct?
think there's a statement already made.
There is, yeah.
In your design report regarding the traffic, so we could maybe go back and look at that. But if there's any more question on that, I'm sure Ms. Clark would be happy to submit additional information.
Okay.
I professionally am not lost to say that traffic can be a significant issue because it leads to standards of full volume road.
Can I just ask, you're saying in the court notes here that you require town approval and it has to go to 22 feet? Is that what you're saying?
No. So there was a conversation. The court on that day was addressing a procedural issue related to affordable housing appeals. And that is, could a conceptual, which is what we had submitted to the zoning commission, both for 91 Boston Post Road and for the Holmes Road property, could he consider that he has jurisdiction over a conceptual site plan as opposed to a final site plan? there was a wide-ranging discussion on what issues had to be addressed. The road issue came up. The court wasn't ordering us to widen the road. We weren't offering to widening the road. We were explaining to the court what the situation was, and in terms of the traffic, I haven't looked at the transcript fully for tonight, but the issue was if the traffic or if the road portion through Monfield needs to be widened, we know that the town will agree to that because the town has already agreed to it for a much larger project. So we were confident with regard to that we could get Monfield's approval if the road needs to be widened.
So, Gary, you're saying because we're a low-level neighborhood and our requirements are 18 feet, it would pass if we were in East Lyme, but because we're in Montville, they have different requirements?
It's possible that Montville has different subdivision regulations and road width requirements.
Okay.
This particular location, well, it's in proximity to the town boundary, it is over 500 feet. So there's no requirement to refer the application to Montville for review.
Because it's over 500 feet away?
Correct. If it was within 500 feet statutorily, we then have to send it there for
So,
referral.
if we put a mall there and it dumped 1 million cars out, we don't have to, we don't care about Montville if it's over 500 feet away?
No, I'm definitely not saying, we definitely care about Montville, whether it's 500 or 5,000 feet. What the regulations require is that if the project's within 500 feet of the town boundary, it has to get referred to the adjacent municipality.
Okay,
And they have the option to comment or not.
okay,
That's what the regs require.
but we're not.
We don't disregard Montville and what they may or may not need, but we cannot approve something in their town, right? They cannot approve something in our town.
I should point out, the reason Montville was involved in the last one is because a portion of the open space, which was originally proposed for the golf course, is in Montville. That's still the case, but it's now all open space and it's not subject to development. That's why I believe the original developer back in the early 2000s had to go to Montville and say, this is the project we're proposing, and Montville said, okay, we're going to want that road widened at that point, and they gave its approval.
I-
What I'm saying is that the existing road width in Montville meets the standards in our town for a low volume road.
Okay, it's just if you drive from the East Lyme side towards Montville, you see the transition from a pretty nicely laid out road into this narrowing downhill, and it just does not seem like it is wide enough to accommodate 40 more
emergency
cars.
vehicles, Emergency vehicles.
Emergency
and-
vehicles,
yeah.
you wouldn't be able to walk your dogs down the street, and it'd be so unsafe. I guess that's my point. Yes.
Three quick questions, just refreshing my own memory. Were these rentals or owned?
These are owned,
Okay. Septic well, both?
septic and well, correct.
Okay.
And that's the issue with Ledgelight. We need to get them to
Okay.
get back out there to finish their inspection.
Actually pulling out the affordability plan,
Yeah, how many affordable?
Yeah, what percentage are you targeting?
6 units total would be affordable.
30%?
Yeah.
The minimum. So 6 out of 20 would be 4.
So there'll be 19 houses. You haven't determined yet where the 20th location is going to be.
Right, but we have to show that it could be a lot on the plans as part of the regulations. There's no special needs.
No, that's not
Guy,
special.
I just to say we're gonna we only are supposed to let the one person here talk. So I know everybody's got opinions, but we're just trying to go one at a time. I have a quick question for this one though, if you don't mind, and I forgive me, Mr. Chairman, if this drifts too much into like the debate section for it. I was just curious if, and forgive me, I'm not sure if this makes sense, but do you have? I know you had talked to us before. Why was this area chosen? for Holmes Road? Do you have anything in there? Was it just the opportunity for the land? Or?
It's the most suitable
Okay.
piece. Right.
Right. So,
And it was discussed with DEP. I had conversations directly with them when we were going through the open space development or grant and so forth. And the DEP said, fine.
and you found even with all of this stuff, this was still the best area that you guys found that you wanted to be able to put. Well, your
Correct.
client wanted to put.
Yeah, I mean, it's level, there's no ledge to speak of out there. So all the things in terms of what we'd have to do to comply with the regulations, we looked at this site and said this is the most suitable one to be able to do that.
Okay.
And that's one of the other reasons that it's the size that it is too, because we were trying to minimize the area that we use for development.
Thank you.
Anybody else?
I would just like a little clarification in the affordability plan, item 2, section C.
Gary, can you tell me what that?
Says the affordable home shall be provided on a pro-rata basis. A total of 14 residences will be designated affordable in the neighborhood developed. 6 single-family lots will be determined by discussion between the applicant and the town of East Lyme to be designated affordable. I think that is clarification. It sounds like 14.
Correct, yeah.
There are 14 lots, but there's only 6.
Right, so I'll clarify that with. That's it? Okay.
Anything else?
All right, thank you.
Did anybody else have any further comments or
Yeah.
in the audience?
I do.
okay.
Sorry.
No problem.
So, do we know the electric service on the Holmes Road is sufficient to, support another 20 homes? Have we looked at that at all?
Electrical service?
Yeah.
I haven't looked at whether or not it's sufficient to support that. I would anticipate that it is. That's certainly a question for Eversource. We do require utilities to be installed underground for our subdivision regulations. So that's the extent that we go as far as providing electrical, cable, utilities, water, sewer, as well. Underground. We don't go any further than the availability unless it has to do with sewer, and that's capacity.
It's all septic.
Obviously, Eversource will probably work with them on the road in terms of lighting and where the street lights are located. Typically, they're at curves and tangents. I don't know if those locations have been identified yet.
We all right with this?
Yeah, I'm just trying to understand if we have 6 out of 20 homes that are going, 6 will be affordable, the land will be held by Deval, and the other 13 or plus 1 will be, other people privately own the property, so they'll be maintaining their properties. The properties will hopefully appreciate for them. It's a good incentive for them to, upkeep their properties and everything. And then you have the affordable housing properties where, really can't rely, the property value's not gonna go up, right? You gotta keep it at that same price.
Not significant, yeah.
So I'm just wondering how that would contrast with the values of the house. It could be right next door, right? You could be right next door to 3 houses, and those people right around there, that might negatively affect them.
So the maintenance or lack thereof will affect
Yeah.
the market rate.
I guess I'm just bothered, and I know this is the Connecticut 8-30G law, but it's used as a loophole, let's face it, where a developer can come in, put a 20-lot subdivision down, not have to abide by any zoning or planning rules, to basically get away with developing 14 lots at a half-acre piece. It doesn't seem right. And out in this remote area with a narrow road, plus all the other issues with the fire pond, it doesn't sit well with me. That's my opinion. That's all.
You can speak.
First, I'd like to apologize.
Yeah, say your name again, because
Paul
you're recording.
Mastriani. I'd like to apologize for the date. He was right. I took the transcript as being new on 310, where he was right. It was a different date for the court. So I'd like to get that straightened out. First, I don't understand, because what I printed out was from this particular date. And this particular date says Duval Partners versus the Town of East Lyme Commission, which they're talking about, where I couldn't find anything else, where it says on Route 1, specifically on a state road, no state road numbers or anything. So that's why I was speaking on what I did give to the people. In here, if you go through it, it does talk about, let me get it here. I had it about the traffic. Where that? Okay. On page 29 that I put in, line 1, court, well, they won't require anything but for a final site plan. Do you need a traffic study? Attorney Garrity, we would need one for the town, more likely, yes. At the last meeting, the first few things out of his mouth was about the traffic and people talking outside of here about traffic. And there was no big deal about traffic, in my opinion, what he was saying. But now he says we'll do a traffic study, so why can't we do a traffic study now? Thank you.
Apologize for that. You're right, you're good. I know it happened. Chairman, give me a second.
Was that? Yeah.
But just to address, so I know what happened and why the gentleman came up with the March date, because that's the date the transcript itself got filed with the court. So you see it pop up on the calendar on the date of filing would lead the average person to think that, okay, this was the date that this took place. It's not. The transcript was filed on March 10th because we had a status conference afterwards, and I wanted the transcript to be available for the court to the extent any of the lawyers referenced it. The issue of the traffic, though, when this was on, was because it was a much different project. It had the multifamily in there, and so there was a question as to whether we'd need a traffic study for that, whether the zoning commission was going to request it. The other issue in terms of the Boston Post Road is because the case caption on it has two case captions, one for the Holmes Road property and one called English Harbor Capital Partners. That was the 91 Boston Post Road. But again, when you go to the judicial website, they don't show you that the two cases have been consolidated. They have one case, they have the other case. So again, unless you knew that, you wouldn't really pick up on that aspect. So I can understand where the gentleman was coming from with regard to that. That's all.
Thank you. Yes. No further comments. I guess we can discuss whether to do a continuation till the next June meeting. Oh, I'm sorry. I'm sorry.
Yep.
Heather Longo Rassicot, 38 Holmes Road. Just had a couple points. One, the reference to the prior approval from the golf and equine facility encompasses both the land trust property, the proposed development property, as well as my home. That was all part of that, so it was a much larger scale. But I wanted to get on the record at this meeting will the town be providing seismic meter monitors for all of the residents in the area if this project is approved, so that we can see if there's any impact once drilling and blasting starts? You know, I know that there's a big risk. We had a lot of, in our neighboring town in Waterford, when they developed a large scale, we had significant impacts to foundations many miles away from the blasting and the drilling of the establishing of the wells. And I just want to know if the town's going to be providing those to those of us in the area that are already established, and how do we go about making that request?
I would say, to answer that, the town does not provide seismic meters to residents of the town, well drilling or single family development. That would be something that's put on the person who's either drilling the well or blasting. They would have to do a pre-blast survey. That's kind of honest, whoever owns the property in which the activity is taking place, the blasting or drilling, I would think would be the ultimate responsible party to do that pre-blast survey, and have the company or vendor that they hire does that. You certainly, by bringing it up here, you brought to their attention. I don't think it's something that we actually can really regulate a whole lot of. We don't have any regulations for it, for blasting. So I would think, maybe as a condition or something to that effect, if there's blasting that's needed, to, I guess, install the wells and or construct homes, roads, whatever, and that's something that we make a condition, say, okay, it's warranted, then yeah, we need to be pre-blast surveys. That's typically standard in the industry.
Thank you.
Thank you. Anybody else?
I have one more question.
Sure.
Have you guys calculated based on the formula, 80% times 30% times the median Connecticut wage, what the price of the house will approximately be? Have you guys looked at that?
Well, so the affordable housing plan is a formula that the state has developed. So it looks at the median income. I'm not, as I stand here right now, I can't tell you exactly how it works, but they look at the median income for that. And then the affordable units are priced according to the formula that's derived from the state, or derived from the median income for the town. So the housing would generally be priced based on that. So those 6 units, and they could be sold outright, to address 2 of your comments on that. With regard to the care of the properties, once they're sold, that's up to the individual owners. I mean, I live in a subdivision, there's a house across the street that's in foreclosure, been that way for 2 years. They don't maintain it. I can't do much about that. The town can't do much about that because it's private property. And, if somebody wants to not maintain their property, without a homeowners association, there's not a whole lot that you can do. Same holds true for all the other houses up there. If one of those houses goes to pot, so to speak, the other neighbors don't have much other than if it becomes a health nuisance or something along those lines. There's going to be a homeowners association here, so there's going to be some ability to control the maintenance of the properties and the upkeep that addresses that concern. The other issue in terms of your comment regarding the power, so when we do this, we have to go to Eversource and show them the plan. They'll require us to develop engineered plans for the layout of the electrical. They will also make a determination at that time whether the transformers on the street are sufficient enough to support the additional capacity that's being requested from them. So that should take care of that as part of the process with the Eversource.
So based on the formula, you could have, say, a $200,000 home next to a $500,000 home.
No, it's more like 80 to 70% of the price of the other home. So they're not. That's one of the things with the affordable housing is that because it's based on the median income in towns, right? Depending upon where you live, And affordable housing could be vastly different if you're from Greenwich to East Lyme in terms of what the base price is for an affordable
Yeah,
project.
it still doesn't get you very high.
I think by definition, it's 30% of family's income or less is deemed affordable housing. That's how it's calculated. And the median income in this town, it's based off of that, like Attorney Garrity said.
If you look at their affordable housing plan, the last page has the state median income for 2024 to 2025. And shows you relative family size for families 1 through 8.
Yeah.
And what those percentages are. So 30% of the state median income is 22,000 for a family of 1. Whereas if they were a family of 4, it's 43,000. They would qualify, clear qualify. I don't know if that's helpful.
No, yeah, it is, but then they calculate how much you, after, you know, your mortgage and taxes and utilities, how much you have to pay for your mortgage, and I would think then you'd have to price the house to accommodate that, right?
Well, you would. I mean, part of when you're going in here is you're looking at what obviously what the town numbers come out to be for affordability. So the houses that you're going to construct, even the ones that are not subject to the affordability regulations, are going to be pretty similar to, if not identical to, those houses. The difference is that under the statute, you basically get a little bit more in terms of what you can put on the property so that the developer can offer the houses on an affordable basis under the statute.
Mr. Chairman, it's just maybe
Thank you.
this might be good if maybe we talk about this after the public hearing.
What's that?
Maybe we can table this for when we have the debate. I just don't know how much more new information we're going to look at, right?
Well, as long as the public hearing is open, we can continue this discussion.
I just wanted
Right.
to look at that.
But, we've got a request for the continuance.
Yeah.
There's been a lot of discussion we did hear from the public. I think if you have specific questions regarding the affordability, feel free to formulate them, forward them to me in a memo. I'll be happy to give Mr. Gary to answer.
Okay.
That's helpful.
Yeah,
Or if I can answer them, I'll answer.
okay.
Thank you.
In the affordability plan, what might be helpful is it shows you some examples. It gives a rental rate, but uses 145,853 as a median income for a family of 4. And as you go through that calculation, it's like roughly a $2,600
Median income is
month
that,
rent.
is it
So
2020? That's new money. So,
All right, thank you. If there are no further comments or discussion, we can discuss continuation to the next meeting for the public hearing, for Mr. Garrity's request. He's looking for, I guess, information.
Just a motion to continue.
Yeah,
Right.
make a
I'll
motion
make a
to
motion
continue.
to continue.
Sorry. I think Cindy just said
We
it.
both-
I'll make a motion to continue.
okay.
I'll second it.
Thank you. Do you have any other discussion? All in favor?
Aye.
Aye.
All opposed? Any abstentions? Thank you. So we have a continuation to the May meeting. May 13th is the next meeting. Thank you. Next up on the agenda is an application of subdivision application for Stephen Hardy, Portside Holdings Incorporated, English Harbor Capital Partners, LLC owner. Application for a 3-lot subdivision of approximately 6.0 acres of land zone RU40 on property located at Heritage Road, East Lyme, Connecticut. This did not require a public hearing. Any
Thanks, Brad.
Gary, some questions whether require wetlands approval and Yes.
I think we can answer that question, if there is, if that question still remains. So, before you, I just handed you a memorandum regarding my final review of the application. We did finally hear back from the town engineer and Ledge Light, both who indicate that their comments and concerns have been addressed and are satisfied. So I did put together some findings regarding the application. We would have until April 20th, 2025 to render a decision on this. I believe it was received at the February 11th meeting. I don't know if you have any questions. I know you're just getting that tonight. There's a couple of pages there to read in terms of the findings. I'm more than happy to go through them if you'd like. I think most of you know the property zoned R40 to the northwest is approximately 117 acres owned by the town of East Lyme, is designated as open space, and the remaining land around this area is comprised of single-family residential homes. We do have the sanitation report, which is Exhibit 34. Also provides for the water supply report as well, and that's a memo from Danielle Holmes dated March 26, 2025, and indicate that lots 1 through 3 are recommended generally suitable to be served by on-site septic and well. I believe there was one condition that she had for lot 2, which was a larger well radius to be adhered to. We received the archaeological report in Exhibit 5, indicating there are no known significant archaeological resources on the subject site. We have correspondence from the zoning official indicating that it appears to comply with the zoning regulations. I believe he did have a comment as it pertained to the CDD regulations. So I can, again, continue to go through all these findings, but I don't believe Mr. Mulholland had any specific issues with the proposal. They do provide lot access. We did indicate that the area, the slope of the driveway is such that it needs to be paved. They've subsequently revised the subdivision plans to reflect that accordingly, as well as the drainage design report, which is, again, as I said, was reviewed by the town engineer. I did provide you some draft language in addition to, at least as a jumping off point. I would note that as part of the record and what got entered, there was a plan in there regarding access to the adjacent open space. So I have got correspondence from the applicant who indicated that they did not necessarily want to make that negotiation with the land trust. I think I'm sorry, English Harbor, and I guess between English Harbor and the town. They wanted to keep it separate from the application. And they were proposing a 50-foot strip of land, 50 feet wide, 50 feet deep, to provide access off the end of Heritage Road to the 117 acres that the town currently owns as open space. So that would satisfy basically the desire of DEP, who granted a open space award in the amount of $400,000 to the East Lyme Land Trust, who then gave it to and transferred that grant award to the town of East Lyme as we purchased the land. However, there is no access currently as the lot configuration at the end of Heritage. So an easement would provide access to that 117 acres. That being said, if there's the proposed open space that's part of this subdivision, which is a narrow strip of land along the rear portion of those lots adjacent to Patagonia Lake. I believe it's the applicant's intent to not allow for public access to that strip of land. I think based on the topography, that may be warranted. In addition, you're going to have 3 single-family lots potentially, and if you had a single-family home, would you just want the public randomly walking through your backyard, even though they could theoretically pass and repass at their own risk? I think it's also the desire of DEEP to keep people off the slope as much as possible. But that is, I guess, the discretion of the commissions.
You mentioned something about the shared driveways and had may not exceed 10% or more of the shared portion of the driveway. Is that something that that'd be part of the proposal, the approval?
Oh, they didn't get deleted? Yeah. Sugar. Okay. You can imagine a little typo. So in my previous memo, I indicated that the driveway, as shown on the plan, was the slope exceeded 15% or 10% and needed to be paved. So Mr. Garrity just pointed out that the lot access, that's section 6-2-5B, lot access, that section is applicable to another project. So please delete that. X that right out.
Which one is it? 6-2?
Page 2 of my memorandum, section 6-25B,
625B.
lot access.
Okay.
So the subdivision application meets the requirements.
And then section 6-7, open spaces, that too you can X out because I can just see that. And again, section 6-9 as well. I'm not sure how those didn't get changed over to the proper, because we're using Roman numerals instead of letters as exhibits, so those are clearly not applicable to this project.
Mr. Gaishel, I just have a quick question on this one. Is this letter for us for approval of the final project, or is this just to go ahead with the subdivision? Forgive me if I'm misspeaking there. I just know I had a question further, but I don't really know if they're prepared to answer more questions tonight.
Well, the applicant can certainly answer more questions if there are any. What I've prepared here are findings for the commission to use should you choose to move forward with the decision. You have until the 20th to render a decision. If you fail to make that decision, I believe the applicant can probably walk away feeling like they've gotten approval. So my recommendation is to take action in some form or matter, because if you don't take action, it's basically automatically approved. Correct me if I'm wrong? Yes. Yes.
Do a continuance so we can review
No,
this?
we have to make a decision by the 16th.
You can ask the applicant if they didn't entertain granting the commission extension, but it's up to them to grant the extension.
Okay.
Not the commission necessarily. We can request it, but they don't necessarily have to grant it.
Okay.
Gary,
Yes.
did you say section 5-6 was
Yeah.
talking about Nottingham Hills? Did I miss that one? 5-6 too.
6-25.
Yeah, touch on Nottingham.
Yeah, sections 5-6, the pesticide report, section 5-8, the archaeological survey, section 6-2, lot design specifications, all are correct. And my apology, nope, section 655, that's the wrong exhibit. Should not be, should be, I believe, exhibit A, which is the design report. Should be exhibit, that should say exhibit 4, Roman numeral 4, which includes the application and design report as it pertains to the pesticide report.
We're taking that one out.
No, don't take it out, just change the exhibit from
Oh, okay.
5 to Roman numeral 4. We can change 6-2-5B lot access, and I would note it would be the last revised plan. I believe it would be dated 3/25/2025. It was revised subdivision drainage erosion control plan by May Engineering. So that would be 6-2-5B lot access evidenced by Exhibit 30 XXX, right? The proposed shared paved driveway has a slope exceeding 10%. And then I would delete the rest of that sentence, and is proposed to be, and I would just indicate that it's proposed to be paved. And then in terms of open space, section 6-7, that would be Exhibit 4 again, which is the design report. And it provides for the open space. So where it says indicates no additional open space is required, I would have to rewrite this entire section. But that exhibit, Exhibit 4, demonstrates the proposed open space. I believe in my previous memo, I think I didn't have any comments on it. I believe it meets the requirements in terms of upland to wetland ratio.
It should be, it says on here it's
Need more time to read the...
no, I just have a question about this part. I can wait till Mr. Geisha's ready, but I have a question about the bonding for the erosion and sediment control. If I can just wait, please. Whenever you're ready.
We can move on to that, but I would just note that you could say Exhibit 4, and I would say Exhibit 26 address the issue of the open space. And Exhibit 26 is the draft conservation easement. Questions in regard to
Yeah, I just
bonding?
have a quick question. I'm probably just missing something here, but I'm noticing on the documents here and on this, it says $25 per lot shall be posted for the town for erosion and sediment control. But there's
20 should be 2,500.
Yeah, I'm sorry, did I say 25,000?
You said 25.
Oh, okay. It does $2,500.
Yep.
And it says per lot, and it says on here though that it says there's 5,000, but there's 3 lots, correct? So shouldn't it be 7,500? I'm just noticing in the document here that it says they're gonna have from May Engineering, there'll be $5,000, but according to this, there's 3 lots. I don't know if that's just an oversight or if I'm just missing something.
I think the total E&S bond for the 3 lots is $5,000.
But I'm just confused because it says in this one that it's going to do $2,500 per lot.
That's right, what I'm
Right.
recommending. That's based on what Mr. May recommends at the bottom. Lots, erosion, sedimentation control, $2,500 per lot. It's going to cost $100,000 to build that driveway, and they're going to need roughly $5,000 for E&S control for that. So you split that amongst the lots at $2,500, you're a little over that. Unless you want to add another $5,000 just for the driveway, that the 3 lots would have to probably, or somebody would have to come up with, but.
I guess I'm just confused, but there's 3 lots.
Correct.
So you're asking $2,500 per lot.
Correct.
So shouldn't that be $7,500?
Total.
Yeah.
Yeah, but okay, so we're not actually asking for them to bond the full amount then.
I'm asking them to provide $2,500 per lot.
Okay, and they're only budgeting in 5,000.
Well, this is just an estimate. They haven't. They're saying that to build the road, the driveway, there's roughly $5,000 in E&S erosion sedimentation controls.
Okay.
And $2,500 per lot for E&S as you build out each house. So add in the $5,000 for E&S on the driveway, divide that by 3, and spread it out over each lot. I think what the intent is by saying $2,500 per lot, that each lot would post its own bond. I mean, at some point,
the developer would typically post the bond, and each individual lot owner will come in and replace it with their $2,500.
I did have a question. I know Mr. May's not here. But we didn't really have a chance to go over it for the last time, which is that in the documents it says that the property owners association will be responsible for maintaining drainage infrastructure. But I didn't know if there was any actual like oversight or enforcement for this, because we run into the problem because it's a private driveway. Correct, that like, I mean, this is where I'm just concerned about this one, is like, is there any actual enforcement or oversight of this?
Yeah, I believe the town would be able to enforce its regulations.
Yeah, but this is a private driveway, correct?
Correct. Approved under the subdivision regulations.
Okay.
So I would think underneath the subdivision regulations, you can require them to
Okay.
maintain erosion and sedimentation controls or maintain site stability.
I just, because I know we don't have a lot of private drives in this town.
Correct.
Well, I believe there'd be an association, right, for those
Yeah.
3 lots
So the
for
associ-
that.
Yes, and they're responsible for the operations and maintenance of that driveway. It was recommended by the town engineer that an O&M plan be provided. And then it clearly described the roles and responsibilities of the property owners and proper maintenance of the rain gardens, PICPs, lawn areas, etc., which contribute to the treatment and attenuation of the stormwater.
I guess I'm really just trying to say, are we as the town gonna have to be providing inspections for this? Or is there gonna be like any kind of a penalty if this is something that they fail to comply with? Because again, this is a private drive.
So I think if they fail to comply with it, we would have to take enforcement action to get them to correct it.
Okay. So it would fall to the town to, I mean, obviously to do that.
To enforce, yeah, I mean, or the association, let's just say, you know, they could enforce it. They'd be the first line of defense, if you will. They should be enforcing it, making sure that everyone's, you know, paying their fair share in the maintenance and not destroying their access.
Yeah, because this road is technically an easement, correct?
Yeah,
Through another property.
right.
Yeah, so.
I just consider, it seems like it could negatively affect the surrounding property owners, and it just, I don't know, it seems a little, like, I know it's a thing that we haven't as a town done a ton with, because we don't have a lot of private drives. I was just curious of how this has been done in the past, I guess.
I mean, as it pertains to, say, the private road on Upper Kensington, it's maintained by the 3 homeowners. We've had issues with washout in the road, and we've told all 3 homeowners, you know, someone at the end of the day is responsible. One of the 3 of you are, and we're going to hold all 3 of you accountable, because that's the association.
Has that worked?
They cleaned up the mess.
Okay.
Can't say it didn't.
I guess I don't know.
Yeah.
I just know I've had a personal experience with like a private drive that is not well maintained, and I don't know of how this has worked for.
Yeah, I do know other municipalities struggle, particularly Old Lyme. I know they've had pet problems in the past with these private roads, and the maintenance and/or the folks living on them wanting the town to take it over in the future. We've explicitly expressed in our regulations, and that notes be placed on the plan, that the town will not take it over, because we don't guarantee that it's built to the town road standard. Yeah, my suggestion would be go apply for a re-subdivision, demonstrate that the road is going to be constructed properly. And then maybe the town will take your road over. So I would add, in terms of the draft language I provided, maybe a 3rd item there, that they provide an operations and maintenance plan for the driveway and rain gardens as recommended by the town engineer.
Thank you.
I was just going to ask Mr. Chairman. I'm sorry. You go ahead. Mr. Chairman.
Are there any other further comments or questions? Or?
The applicant is here this evening. If you have any more questions for them, I'm sure they can speak to that.
I only had one concern, is the ability for a fire apparatus to get in and out of there. But I believe the engineers probably are.
Is that, Mr. Gates, can I ask, is the 2-year previous time, is that typical for these types of ones? Because it just says that this was approved by the town engineer in 2022. So almost 2.5 years at this
I'm
point. Is
sorry.
that-
Do you have a more recent? I think you have more recent.
Oh, do they? I'm sorry,
believe
that's
so.
just what we had in the letter for the most recent
I think
one.
this letter from Alex Close in the.
I just meant for the town engineer, for their,
Oh.
indicating the drainage, the acceptable drainage. I just was wondering more if that's typical, because I know we've said from these other ones that that is, like, that this is meeting the regulations, inlet planning and wetlands is saying that, but 2.5 years ago seems like a long time. I just was curious if that was typical.
I'm sorry, I'm not sure I follow the 2.5
Sorry.
years, where that comes from.
Section 6.-9, it just says correspondent indicated that he would found the drainage analysis acceptable.
Timothy made a report for March 28th of this year.
You mean in my memo, 6-9?
Yeah,
Yeah.
regarding flooding.
Yeah, because I have a memo today that I received from the town engineer dated April 7.
Oh, I don't think I actually got it.
I'm not sure if that's in your
I
package.
must have missed it. I'm sorry
Okay.
about that. That's my mistake.
But
Take a look at that.
I got that Monday, and Mr. Close
Oh, is it this
indicates,
thing at the, no, that's not it. Okay, I guess I just didn't get it, but, 'cause I didn't have this one.
so Mr. Close indicates that the revised plans and calculations provided by the applicant prepared by May Engineering LLC address and satisfy my comments regarding the site's proposed stormwater management efforts for a private, quote, roadway functioning as a driveway for 3 homes with an exception of slope, which exceeded the driveway standard, which requires the road to be paved. And they went with obviously a town road in this case because of that slope issue.
The drainage report.
I'm sorry, Mr. Gay, I must just not have seen it in.
Oh, no problem.
Revised March.
Do you need a copy of it?
No, I got one passed to me, I just, yeah, I believe it, I guess, I'm sorry, I just missed it. Thank you.
Anybody else have any comments or questions? Further, I think
Comfortable making
you're
a
comfortable?
decision.
Everybody else comfortable?
I mean, I don't know what else we're really gonna find after, in a month. I
Right, we
suppose.
have to make,
Right,
basically have to make a decision
I
this,
agree, yeah.
today, or,
Yeah.
what's automatically approved, or he has to,
You need a special meeting before.
Yeah.
right.
Do it like next week, I think. But,
No, I won't be here.
yeah, I think we can move forward on it. I just,
Okay.
am not-
Yeah, I agree.
I'm not sure if I'm gonna have any different of a thought on it in a week
Yeah,
than I
I
would
think
now.
so.
I don't think we'll get any more additional information. In that case, I can entertain a motion. If,
Mr. Chair, may I just address
Sure.
one or two items that were raised
Mhm.
by the commission members? So with regard to the easement and the maintenance of that, there is a, I don't know if it's in your packet or not, but I'll provide you copies. This is just the declaration of maintenance easement for the property.
Oh, good.
What it does is it requires the homeowners, there's a homeowners association being formed for that, to do the maintenance on the driveway. Town, nothing in this document, once it's recorded on the land records, is allowed to be changed without the consent of the town. So if they were to make any changes to that in order to get around things in here, they'd have to come back to the town and say, we want to make this change, and the town could reject that, and it's specified in the document. The other issue, too, is the enforcement issue. The obligation is on the homeowners to maintain it, but the town has the ability to enforce some of those obligations on them. They don't. The other issue is the open space on the water and the access. The open space that the town now owns has 2 existing points of access, one up on Scott Road and one off of Hathaway, so that the public can gain access to the property that way. The area along the water has been, this portion right along that had been conveyed in fee to the East Line Land Trust so that they can control that, and then they're being granted the conservation easement. I asked Mr. Torrance to be here because on behalf of the land trust, he negotiated with DEP the conservation easement, so if there's any questions with regard to that, from my understanding, from my conversations with him, is that DEP did not want to have public access here for a couple of reasons. And one of the biggest ones is the slope down here is very steep on that. In fact, the bank, if you look at it, the bank comes up to, say, down there, but the property starts up there. So there's a gap between the high water mark and the actual land, almost sitting there like you have I don't want to say a cliff, but something similar to that on there. But the DEP did require that each of the homeowners on here have a limited area or access strip to that, so that they can control this, control cutting everything on that. And then the other issue, obviously, is one of liability. If the public were to have access here over the homeowner's lots, it creates a significant issue vis-a-vis liability if somebody gets hurt on their property, or liability for the land trust. And then the other issue is, where would you have them park? You either have to require some additional parking down here, cutting into the lots, or people would be parking up on Heritage Drive. And as I said, there's access to the open space area already from Hathaway Road and from Scott Road at this point. And that was reserved initially when the open space grant was pursued with DEP.
Thank you. Did anybody have any questions for Mr. Garrity?
The lot owners need an easement from the land trust across the wetland.
No, so the DEP is, well, actually, I'd let Mr. Torrance address that.
That strip that was conveyed.
Correct. So, and I think he can.
It's in the deed. Good evening. Jeff Torrance, 197 Upper Patagonic Road. I help the land trust on these open space projects. I deal with DEP on their behalf. I've written the grant applications for the Duval property and the Hathaway property, and actually did the grant agreements that get recorded on the land records. Just so you have it, Gary. That's from Art. The conservation easement that's proposed as part of this particular subdivision, DEP got in the middle of because they're sensitive to the fact that they own the lake. And they are well aware that the town owns the abutting property and owns the better part of 2,500 feet of lake frontage. And we're not willing to concede that the open space be publicly accessible. They said the town owns 117 acres. They've got 2,500 feet of frontage along the Patagonic Lake. You know, they've got enough. This is a steep slope where this property is, and so this conservation easement that's been proposed as part of this subdivision application has no public access attributable to it. I have copies of the, if you'd like. What? Oh, did you give them conservation?
Yes.
Okay. That's the declaration for the road, right? Here's the conservation. Oh, if you can give them the right. Yeah. So if you look at if you go to the third page of the conservation easement. So it's in red at the top, and this was approved by the DEP. So there's about 1,200 feet, a little less, 1,188, I believe, feet of water frontage along these three lots. And what we worked out with DEEP as part of this conservation easement is that each homeowner, based on a set of conditions, would be allowed, upon approval of the East Lyme Inland Wetlands Agency, and a biological study to make sure that there's no threatened or species that the 10-foot is going to infringe upon, that they could build a 10-foot wide pathway. And that would be it. So those bullet points under section F is what's being required. Now, the land trust also acquired the ownership of a strip of land that's about 20 feet wide, adjacent to the lake, which is in addition to this conservation easement area. And the deed for that has the same language in terms of the ability of these 3 lot owners to build a 10-foot wide access to the lake upon approval of the East Lyme Inland Wetlands Agency.
Anybody have any questions? Or? Thank you.
Okay.
I have nothing further. Nothing further? Thanks. Were there any further comments or questions? No. In that case, I can entertain a motion on this proposed subdivision application.
I can entertain that. So
Thank you.
I'll read this with the
I
conditions.
think there was one addition.
Yeah, I got the third one. So
Thanks.
I hereby motion to approve the application known as application of Stephen Harney, applicant, Portside Holdings Incorporated, English Harbor Capital Partners LLC owner. Application for a 3-lot subdivision of approximately 6 acres of land zoned RU40 on property located at Heritage Road, East Lyme, Connecticut. Assessors map 35.0, lot 23-1, which is further subject to the following administrative requirements and required modifications to the site plan and/or other materials submitted in support of this application. Number 1, an erosion and sediment control bond in the amount of $2,500 per lot shall be posted with the town in the form acceptable to the Town of East Lyme Planning Commission prior to the start of any site work, including but not limited to exploratory test pits, clearing, grubbing, filling, and grading. Number 2, the applicable items shall be accomplished prior to the filling of the subdivision or filing of the subdivision on the land records or other documentation of planning approval, and no site work shall commence until all applicable conditions are satisfied. Lastly, number 3, we're recommending that the developers or the landowners operate a maintenance plan as outlined by the town engineer. I'm not getting that right, am I? Who would be responsible for that? The homeowners association to operate a maintenance plan as outlined by the town engineer. This approval is specific to the subdivision plan submitted as the application known as application of Stephen Harney, applicant Portside Holdings Incorporated, and English Harbor Capital Partners LLC, owner, application for a 3-lot subdivision of approximately 6 acres of land zoned RU40 on property located at Heritage Road, East Lyme, Connecticut, Assessors Map 35.0, Lot 23-1. Any changes in the subdivision plan shall require prior approval from the Commission and/or the Director of Planning. Any change in the development plan layout other than those identified herein shall constitute a new application. The owner applicant shall be bound by the provisions of this application and approval.
Thank you. Do I have a second?
Second.
Thank you. Any further discussion? All in favor?
Aye.
All opposed? Any abstentions? So approved, 6-0, the application of Stephen Hardy, Portside Holdings. Thank you. Next up on our agenda are zoning referrals. We have 4. First 2, I guess, can be combined, I guess. Application of the East Lyme Zoning Commission for a proposed zone and map change to rezone all the existing RU 80 zoning district as delineated by East Lyme zoning map and north of I-95 to an RU 200 zoning district. And we have to make a determination whether it's consistent with the POCD. They have a zoning commission has a public hearing scheduled for April 24th. Gary, do you have any comments?
Yeah, I did provide you a memo. You should have all of us handed out.
Mm-hmm. Somewhere in here.
So I basically break down the proposed text and zone change with existing conditions, just highlighting for you the RU rural district as it currently exists, as it's delineated on the zoning map over to your left. The area northerly of I-95, everything that's in white north of I-95 is the area that's being proposed to be rezoned to RU 200. I didn't necessarily provide the map that was submitted with the referral, but just anybody has any questions, you can see it's the highlighted area, entire white space. Right there. This is what they provided.
Yeah, I see it over there. So what's the 200?
So the 200 is, they're looking to upzone the minimum lot area, so this entire white space from RU 80, which is 80,000 minimum lot area, to 200,000 square foot minimum lot area. So essentially,
I've done some math here, and taking a look at the open space, there's approximately 6,313.5 acres of land in the RU 80 north of I-95. It doesn't include the strip along North Brybrook. And of those 6,313 acres, approximately 1,775 acres are classified as existing open space. And that includes Powers Lake, which is approximately 143 acres. 452 of those acres are occupied by a portion of Stones Ranch Military Reservation, and approximately 1,758 acres are occupied by Yale University Outdoor Education Center. So that leaves roughly 4,086.39 acres of potentially developable land, and that land includes wetlands, watercourses, floodplains, and steep slopes. It didn't I didn't subtract that out. I think that was I could get granular, and we could try something like that if you wanted. But essentially, just so you know, 1 acre is 43,560 square feet. Under the current RU zoning district, which requires the minimum lot size, as I said, of 80,000 square feet. That's just under 2 acres. The 4,086 acres of potentially developable land could potentially yield 2,225 lots, plus or minus. Also, under the current regulations, the Conservation Design Development CDD provisions shall be required in the subdivision of any parcel of 10 acres or more if the parcel is located in the RU 40, RU 80, and the RU 120 district. In addition, the Planning Commission may require the CDD provisions in the subdivision of less than 10 acres or less than 4 lots. The CDD zoning regulations require within the RU zoning district a minimum of 50% of the land being subdivided to be set aside as open space and areas with individual septic systems. So that's just about everywhere up there. They would have to come up with 50% open space. In areas within the current RU 80 zoning district where public sewer is available, the open space allocation would be 75%. Checking the sewer shed map and the existing location of the existing main, which is on Route 1, there's nowhere in that northerly portion, that does the sewer shed extend. But I don't believe that there's any plans now or in the future to extend the sewer main any further north than it already is. But again, I could be wrong, you know, there's some plans somewhere. Anyhow, so currently the sewer is not available. Under the proposed conditions, you're going to take that 1.8 acre lot and require a 200,000 square foot lot, or roughly a 4.5 acre lot, minimum. Under that, of the 4,086 acres of potentially developable land, you could yield roughly 890 lots in terms of the difference. Again, under the current zoning regulations, 23.6B, approximately 30% open space of the potentially buildable 4,086 acres equals approximately 2,043 acres of open space, whereas under the proposed RU200, there is no proposed change to section 23.6B of the zoning regulations to specify the percentage of open space that would be required in a CDD subdivision within the RU200 district. As such, we'd only apply a minimum of 10%. Which would most likely be required pursuant to the general statutes. Therefore, in an RU, if they upzone this without changing that section, only 10% of land being subdivided would basically preserve 408 acres. And being that the purpose of Section 23, Conservation Design Development, is to, quote, provide more flexible standards to permit residential lots on specific districts to be reduced in dimension and designed to occupy less than the total tract of land to be subdivided, end quote. It was the intent of the standards to direct developments to the land areas most suitable for development, and that will achieve several objectives, including the preservation of natural or agricultural open space, protection of the local ecology and the quality and quantity of underground and surface water, preservation of vistas, steep slopes, ridge lines, archaeological or historical sites, stone walls, significant geological features, wetlands, watercourses, and other areas of environmental and aesthetic value. So in terms of compatibility with the POCD, section 7.12 regarding housing stock indicates that the economic overview prepared by the Southeastern Connecticut Enterprise Region, otherwise known as Sector for East Lyme, shows that there are a total of 8,739 housing units within the town. Since the printing of the 2020 POCD, I estimate that approximately another 100 to 150 units have been constructed. Maybe closer to 2, but according to the POCD, on average, nationwide, the median cost per dollar revenue raised to provide public service for commercial and industrial land was 0.30. It goes through this cost of services, basically. So the research that was conducted by the American Farmland Trust basically determined that the cost of open space was cheaper than the cost of housing. So despite the common misconception, more residential space does not necessarily equal more tax revenue. In fact, it's the opposite. More residential space typically equates to greater costs as they require public services, such as educational costs, water, sewage, trash, and snow removal. However, with all that said, I would say that the proposed change is consistent with that section. However, Section 7.3 of the POCD recommends the following, and I list all those recommendations. So to evaluate options for reducing the future impact on water and soil resources, particularly in the northern end of town, where there are larger remaining tracts of undeveloped land, consider adjusting agricultural regulations that better encourage and support preservation of agricultural land. Expand allowable uses in agricultural zones, such as events and B&Bs. Continue to promote cluster and residential development as a means of creating permanent open space, preserving environmentally sensitive areas and encouraging creative subdivision design. Revisit conservation design development zoning regulations to improve configuration and connectivity of open spaces within residential areas. Consider increasing open space requirements for subdivisions. I don't know that we would. You're already at 75 and 50%. It's pretty high. Encourage the Planning Commission to utilize CDD regulation whenever appropriate. There's a commercial zoning one that's really not as applicable. Consider additional protections in residential development areas near watersheds and aquifer recharge areas to ensure future development has minimal impact to the watershed or aquifer. Highest priority should be placed on maintaining undeveloped woodlands, particularly those surrounding Powers Lake, Bridle Lake, Dodge Pond, Patagonia Lake, Darrow Pond, Gorton Pond, Oswegatchie Hill, Stones Ranch, and the Yale property. And maintaining and expanding wetlands, particularly in those adjacent to Patagonia Marsh. Improve the resiliency of existing and future residential development by adopting zoning regulations for 100-year stormwater collection. Improve resiliency in existing future residential development by adopting zoning regulations for 100-year stormwater collection, retention, quality, new developments. Evaluate permitted, either outright or by special permit, commercial uses within residential areas. Allow construction of accessory apartments, things like that. Consider moratorium on sewer line extensions. So based on those recommendations, the proposed zone change, in my opinion, would not be consistent with the POCD in that it does not recommend decreasing the density of any of the zoning districts. Rather, the section recommends adopting regulations that will ensure future development has minimal impact to the watershed and aquifer, with the highest priority being placed on maintaining the undeveloped woodlands, particularly those around, again, Powers Lake, Bride Lake, Dodge Pond, Patagonia Lake, Darrow Pond, Gorton Pond, Oswegatchie Hill, Stones Ranch, and the Yale property. The adoption of RU 200 rural district will not prevent the future development of nearly 4,000 developable acres in the current RU 80 zone. In addition, the affordable housing plan, quote, academic research shows that multifamily development, which is most often a higher density than single-family residential development, either has no impact or a positive impact on adjacent and approximate single-family residential property values, end quote. Further, the findings of the housing needs assessment show the greatest need for owner-occupied housing are those households with incomes of $74,999. And based on that study, we are negative 460 units. Demand outpaces the supply, demonstrating the housing affordability need for owner-occupied housing. Moreover, the East Lyme Affordable Housing Plan appendix of the POCD recommends the utilization of duplex and triplex units in lower density developments and subdivisions, provided the number of bedrooms does not exceed 16. Multiple units can exist on a single septic system and not be considered a community system. As such, this creates opportunities for the missing middle housing by adding density to the conservation developments. The plan suggests that the Zoning Commission consider a provision that would allow 20% or more of the units in a CDD to be duplex units. Therefore, the proposed increase in minimum lot area would not be consistent with promoting increased densities to address the affordability need for owner-occupied housing. And that's all I have. So the rest is up to you. You have the discretion to find out whether you think the proposed change is consistent or inconsistent with the POCD, but I believe I've laid out kind of the facts, and I tend to lean that it's less consistent with the plan.
Mr. Gaishel,
Yes.
I know I've talked a lot for this one, but I have a question on this. My biggest thing is, I know I told you and the chairman about this one and soon after, but my biggest thing I end up having here is, on top of everything you said, it's like, the concern seems to be, and I think it's I can appreciate it, I don't know if this is the best approach, that they're concerned about overdevelopment and concerned about new developments, but just speaking into some of these process we've had, if this was going to be, say, an 830G application, this zoning change wouldn't affect that, correct?
Wouldn't make a difference.
Yeah, so that's kind of where I'm at. This seems like, I understand exactly why these ones are proposing this, but it seems like it's extremely inconsistent with the POCD, and it seems like the exact kind of thing that they are concerned about. Like, other towns have tried this. That's kind of why the state put 830G in, was to prevent towns from just saying, well, we'll just make the lots really big so you can't build it here. And I don't even know if we get into the environmental thing. If we're concerned about the aquifer, everything you do here is gonna be more septic tanks. And we know that nitrogen getting into that is definitely causing a lot of problems in our water system here. And I guess I'm struggling with this for the zoning board of how they could propose this and think that this was in any way consistent with the POCD. I understand their desire to increase the minimum lot size to try and hamper development, but we talk about that in the POCD, that's not that we do not think for the plan of conservation development that is the right approach at all.
That was my take on my interpretation of the plan of development. And certainly increasing the lot size and reducing densities, as it pertains to environmental protections or water quality, what that's going to probably do is reduce the impervious area within the watershed. Because they didn't change the minimum lot coverage, so that remains the same. So I've got a bigger lot with the same amount of lot coverage that was permitted before, so therefore I've theoretically reduced the impervious area. We know when the impervious area reaches 10% within a watershed, we start to see direct correlations to water degradation. So I think that's part of the intent, is that by increasing the lot size, they'll reduce naturally the impervious area.
Yeah, I don't know, Mr. Chairman, if this is one, because I know I've sent you guys a lot of reasons as well. I think pretty much everything I said was covered by you, Mr. Gaishel, in there, but like, I just don't know, like, I don't know how much the other members of the board feel, but I mean, I don't want to like tell zoning that they're incorrect on this, but this just seems very inconsistent with the POCD, and I mean, about 4 pages about why it's inconsistent with the POCD.
I'd also note that you had also some correspondence from the Conservation and Natural Resources Commission, a letter dated April 2025. I think you have that in your packet. It was basically their take on their review and support their the plan to rezone the area north of Flanders from a minimum of 2 acres to a larger minimum of up to 5 acres in order to better protect drinking water for the current and future needs of the town. So they indicate that the change is recommended in the plan of development, pages 62, 63, and 71. I'd have to pull those out to take a look. Recommendation for larger lot zoning, better aquifer protection with larger lots in the northern end of town was also supported in the previous POCDs as far back as the early 1980s with the then newly formed Aquifer Protection Study Group, chaired by the late Betty Murphy.
This is about, I'm sorry, Mr. Gish, which form was this one?
This was a letter from the Natural Resources Commission.
Oh, okay, I see, it's on this one, just a second.
Their letter goes on to say the best way to protect our drinking water supply is to maintain as much of the natural vegetation cover as possible and, most importantly, limit impervious cover. Example, roads, roofs, driveways, hardscaping, below 15%. I used the 10%. I believe there's a diagram in the open space plan, which I would reference. I just don't know the exact title of that diagram. But that diagram is a chart, I forget where it's sourced, I think it might be DEP, but it indicates that when you exceed the 10% impervious cover, you start to see degradations in water quality. Enlarging minimum parcel size in the most vulnerable parts of town is an equitable method of achieving this goal. An important second step would be to rezone areas abutting the Nyack River, tributaries from a minimum of 1 acre to a minimum of 2 acres as a transition buffer. This will help better protect the water that flows at the Nyack River. So there's even a plug to increase the zoning adjacent to tributaries and the Nyack River, which is located, as you can see on that map, mostly within the it's the R120 zone to the west of the river.
I don't mean to disagree with the commission on this one, but I guess to me it doesn't seem like I understand what the second step, but if we're going to talk about trying to reduce the number of impervious surfaces, it would seem like there's other parts of the POCD that would be the higher area for doing that, right? Some of what we talked about in the last meeting about the way that we have our more of the Niantic area, and gosh, I have this in here for someone in there about the. I'm sorry, I'm probably not going to be able to find it, but there is some of like essentially building into the areas that we already are. Like I understand where the sentiment is coming from, but this does seem like an approach that is not going to result in the effects that are desired. Again, it seems that what's going to happen to me, and just because we have seen this in other towns, and I apologize if I'm talking too much of this one for some of the commission members. I know we've been here a long time, but if we do this one, it would seem very likely, based on what's happened in other towns, that their developers are going to immediately go to using 830G to get their projects built. I'm not trying to say that one for, I suppose, the POCD part, but that is what has happened in every other town that has tried to do this.
So I'd just like to point out, following the planners listserv, and literally just on Friday, this was sent out from the town of Marlborough. There last night, the Marlborough Zoning Commission approved some sweeping changes. They changed their lot sizes, changed from 80,000 square feet to 40,000 for well and septic, and reducing frontage from 200 feet to 150. They went from 50,000 square feet to 20,000 for sites that have public water and or sewer, and reducing frontage from 175 to 125 feet. Permitting duplex as of right with no extra acreage requirement. Increasing inclusionary zoning for 10% to 15% affordable units required. And reduce front and rear setbacks from 50 to 40 feet. There was no opposition. Residents recognized the need to create more opportunities for development. Some thought the reduction of lot size, frontage and rear setbacks should have been greater than presented. Only one person felt we should have larger lot sizes and environmentally sensitive areas. We held a public forum in February, with et cetera. So I think it's just an example. There's a neighboring town, well, they're not on the shoreline and adjacent, but Marlborough, Connecticut is, a little smaller than we are. They're located inland, but they had large lot zoning, or at least 2 acre zoning, and they're going the other way to create housing. So I thought that was quite interesting to see. So just as some context as you mull this one over. But,
I really don't mean to belabor the point, but it just seems like it's pretty clear where we're at for this. And I guess really what I'm asking for this one for the commission, because I know several of you guys were on it when we had the POCD, is there, and I wish because Mr. Scott would probably be good for this one as well, is there a good way for us to, I don't want to get ahead of myself, but assuming that we're going to say that this is inconsistent with the POCD, to make a recommendation back to them about what the best approach, because I very much understand, I feel like, where this commission is coming from. I just don't think this is the right approach at all, and the POCD would say that this also is not the right approach.
This is in chapter 6 on open space.
And if I can add, it's also not consistent with our affordable housing plan,
So I would say, so as part of your motion, what I've advised past commissions is you'd pass your motion, finding it consistent or inconsistent, and then you would forward on a series of recommendations with it. So I think if you forward on the recommendations that are specific to the POCD, as I've even called out some of them, and then if you have specific ones you want to call out, you can recommend that they consider those sections. Consider, so I would consider revising your zoning regs.
The affordable housing plan, we want it to be near public transportation, more.
Yeah, and if we're doing it this way, it's just going to result in that they're going to be doing these exact. I probably shouldn't. It would seem that the kind of projects that this is trying to prevent from happening would, if anything, would not change in their likelihood at all. That there would be just as much likelihood, because they can simply say, okay, well, we're going to ignore those rules by using 830G.
Correct.
So they can just do this anyways, and they'll just use it and be like, okay, well, we're just going to ignore you and use this to do it.
I would recommend an overlay zone. We used to have a primary and secondary aquifer overlay, which we repealed, and we adopted the APA zones, which you can see on the zoning map to your left, are they're hatched areas in red, crisscross hatched. I would say in addition to those are overlay zones. They have specific and permitted and non-permitted uses within them. If you adopted what was previously known as the primary and secondary overlays, they extend to, at least the secondary overlay, extended to the boundary of the watershed, which is well up above Powers Lake. When you look at the Patagonia watershed, it's not on that map. I can't show you there, but it extends well above Powers Lake. And the idea is that you would be protecting those areas with an overlay zone by adopting regulation, just like the POCD recommended. Just my suggestion is that they consider an overlay versus rezoning the entire north end of town. We haven't even got into the discussion of what it's going to do to land value. I would note it was obviously supply and demand. It's going to increase the demand. And then we know what happens with that. The price of housing is going to go up. The price of rentals are going to go up. I would also note that we just recently adopted a Fair Housing Commission because of the cost of housing. So as we deal and contend with all of these different
is there a specific
issues?
Oh, sorry.
Yeah, go ahead.
I suppose for the 3 or 4 of us who are on the POCD, is there a specific provision in the POCD about cluster zoning or?
Yes.
Okay, I thought so. And I mean, that seemed, I know that when I said this to this one, I had said, I thought we should be emphasizing more of this, of trying to have more cluster zoning.
trying to have more of that. I think it's talked about it, as you had in there, the mixed use and the denser housing, or in the village zones for Flanders and Niantic, and for trying to do the strengthening the open space. I mean, to be honest, Mr. Chairman, I think the biggest thing I've mentioned, I don't really know where to start for how we can
Well, I mean,
say
the
that
that's
this.
there, that we're basically giving a recommendation, zoning can make their own determination.
but that's-
But I guess we can just quote
Mr.
information
Gaishel.
in certain chapters.
Yeah.
Chapter 5 is natural resources, chapter 6 open space.
And I mean, and they can choose to override us, I suppose, in this one.
Correct.
Right,
Yeah.
so the two, the four.
So you-
4-2
It's
vote,
just a
but-
recommendation. Chapter 12, I guess, wastewater management discusses sewage capacity. I think there's been affordable housing in there too, I guess.
I mean, I guess I have to this one. I do mean as like, are we able to just quote I just feel if we try and go over everything that we've got that's wrong in this one, we're gonna be here a little while.
Could I make a suggestion?
Yeah.
They just move to find that the proposed zone change and text amendment is inconsistent with the 2020
we'll have to.
POCD based on the findings
I
in
just know
my
that
memo.
last time we did a whole thing to specify why we did not approve.
You could say specifically,
Well, we had to weigh the options, I think, last time. There was like 3-2,
Right.
3
That's
pros and 2 cons, so I think the scale is just tipped dramatically. and-
you could say based on some of the findings, you could outline or
those
specifically
findings.
state which
I mean,
findings
it's-
in here in that memo that you agree with, and then you could say, hey, we recommend you consider an overlay zone for aquifer protection. I'd recommend maybe an overlay zone, I'd call it an agricultural overlay for the RU80. What about that? There's an option there. If you want to promote agricultural uses as well, that would be beneficial. And I think in terms of sustainability and the town, well, let's support some of those agricultural uses. I know there was a desire to help promote them, so let's adopt some maybe regulation that would do that.
Do we need to make a motion for this one? Can we make a motion to reject this and include the reasons that are given in Mr. Gaishel's letter for why this is inconsistent with the POCD, or is that?
If I understand you correctly, you're saying if you make a motion to find it inconsistent with the POCD based on the findings in my memorandum,
I mean,
that works?
Yeah.
Yeah.
And we'll forward this memorandum on
Yeah.
to the zoning.
That-
It's
that-
going to them anyway, it's going to Mr. Mulholland.
I just figured for Mr. Gaishel, this is very thorough, and so I appreciate that from your office, and I feel like you probably have done as good of a job as we could possibly do up here in trying to determine all the reasons of why we have an issue with this.
Thank
So I
you.
just
Yeah.
refer to the memorandum.
Yes.
Easiest thing.
Yes.
Okay. Can I make a motion to do that?
Sure.
What I just said?
Okay. Do you have a second or?
I'll second.
Second. Any further discussion? No? All in favor of saying that this text amendment is consistent with the POCD? Say aye.
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 All opposed? Any abstentions? Okay, thank you.
Now, Mr. Chairman, I had a quick question on this one. Do we need to, as I know Mr. Gaishel kind of addressed this with both parts of this one in his testimony, do we need to do that again for the next part?
I was under the
That's-
impression you took both of these out.
Okay.
Yeah,
I think combine the two.
I just wasn't sure if that was because it's technically a separate agenda item.
Yeah.
Well, I would, how do you have it in the minutes, Jan? As one item, or they combine it?
What's on the agenda separately, two different referrals, and one's a text amendment, one's a map change, so there's the.
I mean, I suppose we could.
Yeah, so I would make a second motion.
Okay.
Second motion, that first one was we did the text amendment, now do one for the zone and map change.
Did we do it the other way around? Which one did we do?
We
Because
just
I was
did
assuming,
the
I thought we did the proposed zone and map change, right?
Yeah.
Zone and map or text?
Yeah,
So
the proposed text amendment.
I just know it came to you as two different referrals,
Okay.
so that's.
I just don't know what. Yeah.
Your motion was to, I guess how was it worded? That would be.
I suppose I wasn't clear enough on my motion, so I apologize that. Okay, so just to get this one clear, on this one, I'm going to make a motion for us to reject both The first application for the East Lyme Zoning Commission proposed zone and map change to rezone all the existing RU80 zoning districts as delineated on the East Lyme zoning map and northerly of I-95 to an RU200 zoning zone. And the application of the East Lyme Zoning for a proposed text amendment to the East Lyme zoning regulation by adding a section 2A RU200, updating the section identified as necessary as inconsistent with the plan of conservation development. And I want to cite the information that Mr. Gaishel's memorandum had refer that to the zoning commission. Did I cover everything? Okay, so I guess we have to do this.
Okay. Do you have a second?
I'll second.
Second. Any further discussion? All in favor?
Aye.
All opposed? Any abstentions? Okay. Thank you. Let's see. So we have two more.
There's two more. I believe they're scheduled for a May 1st public hearing. We can take a quick look at them. I was hoping we'd get to our next meeting because I have not had an opportunity to take a look at either
It
of these.
does look though that our next meeting is after this public hearing is scheduled though.
One is May 1st, the other is May
All right.
15th.
Yeah, our next meeting.
We'll be okay for the May 15th item, but the
Right.
May 1st, I think we're going to have a little problem there.
I'm just, oh, never mind, sorry, that is my bad.
So certainly, it looks like they want to add some additional controls to section 25.5. This is the text amendment. To amend the commercial zone, section 8.2.2, by replacing the current language with new language with additional controls. Looks like.
So basically, they're searching for flexibility in terms of mixed use housing.
Well, like I said, I haven't had an opportunity to really take a deep dive on this. So as far as what the existing regulations states, I don't know.
Mixed-use dwellings. If you cite the materials off the webpage, it's in there. There's a memo.
Oh, shoot.
Square footage not greater than existing first floor. I think those are the
Uptown Cal.
attic rooms at 22 height.
I'm not sure I'm clear on what the amendment to section 8.2.2 is. It looks like they read identical.
It says add CA zone to the existing mixed-use controls to be subject to items 1 through 7 above. I'm in the memo.
Under the referral, saying
Yeah.
there's a proposal for a text amendment to mixed-use commercial CA zone section 8.2.2, comma, by replacing current language with new language, comma, with additional controls in section 25.5. So I would think there's changes in both sections. But it doesn't look like it. This reads almost identical to section 18. But I have it here. So maybe it's just section 25.
If I'm reading this, it seems that they're just adding
more area? Is that correct? Because it seems in here they're just adding more of an area where they could potentially build this. Is that, like, does anyone else have this in front of them? I don't know. You read that as any different on this one? Because it says that they're just adding from the CA zone, it's allowed in the following areas. The intersection of Black Point Road and Main Street, so that the intersection of Crossing Court, intersection of Drive. It seems that we're
It's in the
adding
materials
more area they could potentially
section
build
on
mixed
the
use zoning.
webpage. So.
CA zone.
That seems easy for us, and then POCD wise, that's gonna be okay.
I mean, I don't really see anywhere where it would affect the POCD, really. It's just specifying.
Yeah, it just
things.
seems like it's being available in a slightly larger area, which would seem consistent with the POCD.
Yeah. Seems fine.
In fact, it's specifically in here that we want more mixed-use zoning in some of these areas.
Yeah, because you can get some affordable housing in there.
Yeah. It just, yeah, it just seems like it's expanding it from Black Point Road and Main Street, so the intersection of Crossing Court and intersection of McKinley Drive. Unless I'm misunderstanding something. Okay, yeah. All right. Does anyone else find anything?
Yeah.
Yeah, I mean,
Definitely
it
CLCD
seems
very
does support
consistent with the
mixed use.
POCD.
I don't
Yeah.
see anything in there that would be inconsistent.
Discuss.
Yeah, I mean,
Just want to expand the zone. I think they want to maybe help regulate and preserve areas that have
yeah.
historical value.
I think we can all agree that that's consistent with the BOCD.
Yeah.
Yeah.
Yeah,
No?
I mean, I'll
Does anybody have any
continue.
further discussion?
No, I mean, I'll make a
Okay.
motion that we approve this as
Consistent
consistent.
with
Yeah, the 8.22, sorry. I make a motion that we approve the application of the East Lyme Zoning Commission proposed text amendment to the East Lyme zoning regulation of modifying section 8.22 mixed-use commercial CA zone and updating the sections identified as necessary. I make a motion that we approve it as consistent with the POCD.
Second.
Any other discussion? All in favor?
Aye.
All opposed? Any abstentions? Nope. Thank you. It's passed 6-0.
Yeah.
Now, the other text amendment, the public hearing is scheduled for May 15th, so we have time, maybe one more time to review it.
Yeah, we
for-
do have more time to review it if we need
So we
to.
can make a motion next meeting if we need to.
If need to. I mean, it's worth taking a look at it. You might be able to act on it relatively quickly because it's very similar to the one you just looked
No.
at, but it does affect lot size and what they're looking to change there. So there's some dimensional requirements that they're looking to delete, and then some controls that they want to.
It's basically consistent with the other
So I think
text
it's.
amendment, except a different zone, obviously.
I'm not actually sure I understand. So, Mr. Mahan, if I'm understanding correctly, we're getting rid of the section that says that mixed-use development can only happen in existing buildings only. And I'm not sure if I understand, shall have a minimum of, I'm sorry, I'm just not sure if I'm reading this very well.
So basically, it would allow you to build a new building to have a mixed-use
I
development.
got that part.
And then you're going to, if you're going to have mixed use, for a two-family dwelling, you need a minimum of 20,000 square feet. And then all lots used for residential purposes shall have a minimum of 10,000 square feet. So I believe if you need 20 for a mixed-use development.
Yep. Two family dwellings have a minimum of 20,000. Okay.
And then, again, here's You can see what they're adding, a traffic study if it exceeds 15,000 square feet. So obviously, if you have a mixed-use development, you're going to need 20,000 square feet and a traffic study.
Yeah, it seems like
So it is a little bit lengthier. I'd be happy to take a look at it. I'd like a little more time to review it and properly report back to the commission my thoughts, but
Okay.
We can do that, yeah.
Mr. Chairman, can I make a motion that we, delay this until our next meeting? The proposed text amendment to the East Lyme zoning regulation by modifying section one.
Table it to the next
Table,
meeting?
excuse me, yes, table this zoning referral to our next meeting on May 13th?
Made a motion?
Yes.
Okay. Do you have a
I'll
second?
second it.
Thank you.
I'll second it.
Any discussion? No? All in favor?
Aye.
All opposed? No. Any abstentions? Thank you. And, okay, municipal referrals, none. Old business subdivision regulations, section 4, application submission procedure. Anything new on that? Or?
Nothing new on that. I think I reported at the last meeting that Attorney Bleasdale has kind of taken over the reins for Attorney DeMarco, who's since retired. So he's basically, you may or may not know, he's in the wetland agency. He's also working on regulation changes, basically kind of a complete overhaul of their regulations. So he's currently reviewing that, so that's the entire document. Versus, I was hoping just to do one little section to quickly look at, but in the process of workload, unfortunately, things are not delayed. So, with that said, we did indicate that we were working on it, so hopefully in the next month or two, we'll get a response back from him. So I'm hoping by next month, we did indicate that in several since December. Later, I did let him know that the commission is anxious for the report.
Thank you. New business, we have none. I can entertain a motion to adjourn.
Motion to adjourn?
Thank you.
Second it.
All in favor?
Aye.
All opposed? None.
Who opposes that?
Okay.